Okay, everyone, new developments this week in Don Lemon's criminal case, which weren't necessarily surprising, but it is cathartic to hear it from the government. The DOJ is now saying openly this week that there could be additional charges. The government said that twice in a new filing this week. So I'll say this right now. If the government doesn't add new charges or doesn't come up with a new superseding indictment, that would be more of a surprise at this point. So what might the new charges be? If I had to guess, and I've talked about the next wave of anti-ICE protesters who seem to have taken up residence outside City's church and are forcing the churchgoers to walk through a gauntlet on their way to Sunday service every week. Now, that new group of agitators might be added to the indictment, especially if there are incriminating contacts between the new group of activists and the existing 38 defendants in the current indictment. For example, if the leaders of the conspiracy, Nekima Levy-Armstrong and Chantel Allen, are coordinating the current gauntlet, something along those lines. So it would be an ongoing conspiracy to harass and intimidate churchgoers. The defendants probably would call it ongoing civil disobedience. In any event, it shows lack of remorse by the current group of defendants. And the government is still going through the cell phones and the rest of the seized materials, so new charges could be added just for the current group of defendants based on conduct that we don't know about yet. I also wanted to discuss an issue that's been ignored. Why these churchgoers? Now, the defendant's reasoning probably is that a field director for ICE is the lead pastor or one of the pastors for City's church. Now, if I had to guess, they're trying to make him quit. Now, whether he does or not, it could come at a very high cost because the leader of the alleged conspiracy, Nekima Levy-Armstrong, is a licensed attorney. Now, if she's convicted of a felony, she could lose her law license. It would be up to the lawyer disciplinary board in Minnesota. Now, lawyer regulation is done differently by each state. Now, maybe Minnesota will take a liberal approach. I believe that folks who don't know Minnesota, for instance, were very surprised that even the judiciary is somewhat supportive of anti-ICE activism in Minnesota. So maybe Minnesota is different from, for example, New York with regard to lawyer regulation. For instance, Collinford Mattis, age 34 at the time. Now, this was a couple of years ago, and Uruj Rahman, 33 at the time. They were licensed to practice law in the state of New York. And I say they were licensed to practice law because they're not anymore. They threw Molotov cocktails during the nationwide protests after the death of George Floyd. They both served prison time, and disbarment was automatic for both of them because of the felony convictions. Many states follow that rule, automatic disbarment for a felony conviction, because felony convictions would even get them stricken from just about every jury panel, for instance, if they were called to jury duty, because attorneys view folks with felony convictions as no longer capable of being objective about the legal system. So they can't serve on a jury and maybe wouldn't even receive a jury summons because the jury pool is often taken from voter rolls, and some states strip voting rights after a felony conviction. Not New York, though. So potentially they could be called for jury duty, but they wouldn't get on the jury. Now, when we think about the amount of hard work and dedication it takes to become an attorney, to have that taken away is a devastating blow. There are procedures for reinstatement to the bar, but there's usually a 5 to 7 year waiting period in most states, and the petitioners have to show that they've been rehabilitated and meet the requirements for good moral character and legal competence. Now, back to the new filings. The government filed a consolidated opposition to several repeated motions filed by defendants over the past several weeks for disclosure of grand jury materials. Now, a motion for grand jury disclosure is a long shot anyway because grand jury proceedings are supposed to be secret to protect the anonymity of witnesses and grand jurors. Now, this week, the judge denied those motions in Don Lemon's criminal case without prejudice. So the motions can be refiled. And there's a pending motion for Brady disclosures filed by Georgia Fort. Now, I discussed that in last week's video, and Georgia Fort is asking for grand jury disclosures as part of her request for Brady materials. Now, the government answered Georgia Fort's motion this week and said it wants to voluntarily disclose 2 lines of testimony from a grand jury transcript to the judge in camera, meaning in chambers away from the defense. Now, just to summarize from last week, Georgia Fort had accused the government of misconduct before the grand jury because some recently unsealed search warrants revealed that an agent for the government had drafted an affidavit that accused Georgia Fort of chanting anti-ICE slogans in the church, such as "ICE out," "hands up, don't shoot," etc. But that allegation didn't make it into the indictments. Now, this week, the government responded to Georgia Fort, saying that she wasn't indicted for chanting because the government agent made a drafting error in drafting the affidavit in which she was accused of chanting, along with the anti-ICE activists. So the government says she's not being accused of chanting and not being accused of using her camera as a weapon of intimidation, quote unquote. That was a phrase from the government agent's affidavit as well, which didn't make it into the indictment either. Georgia Fort's defense says, well, those false allegations could have been repeated to the grand jury, so disclosure is necessary. Now, the government says it wants to share just 2 lines of grand jury testimony with the judge in camera, just to alleviate that concern. So my guess is it's testimony from a different government agent who could have said, there were a number of affidavits filed without U.S. attorney participation. The affidavits were unsworn and not accurate to our standards, or something to that effect. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.